And the Senate President says he is satisfied with the ruling of the Supreme Court, which struck out his trial at the Code of Conduct Tribunal. In a statement personally signed by him, Saraki expressed gratitude to all Nigerians who have supported him since the case commenced 3 years ago, thanking the judiciary for doing what is right. And in that regard, the Supreme Court on Friday finally laid to rest the trial of the Senate President, Bukola Saraki, on assets declaration and sundry charges instituted against him before the Code of Conduct Tribunal, a 5-man panel of the Apex Court led by Justice Datijo Mohammed, unanimously upheld Saraki's appeal by dismissing the remnant 3 counts, declaring the evidence led by the prosecution as hearsay. The Danladi Umar-led CCT had in June last year terminated the trial upon an application by Saraki by dismissing the entire 18 counts preferred against the Senate President. Constitutional lawyer and social affairs commentator Kennedy Osunwa joins us now to discuss this development. Many thanks for joining us.
Thank you, and good afternoon.
Is this a surprise, considering that ahead of this verdict, his colleagues, as the Senate President's colleagues, had called for an end to the trial and all the charges preferred against the Senate President?
Yes, I want to commend this decision of the Supreme Court, Federal Republic of Nigeria, being the final arbiter. What this judgment have demonstrated in the exercise of the Supreme Court powers conferred on it by the incursion of Section 233 of 1999 Constitution, he has exercised its appellate jurisdiction to evaluate the evidence that was tendered by the prosecution, both at the Code of Conduct Tribunal. And the Supreme Court discovered that the evidence that was tendered had no direct link with the witnesses. And what this goes to show is that it is incurably defective, in the sense that the witness ought to be a direct person that had first-hand information with the documents that are tendered. The documents tendered were not also tendered by the makers of those documents. So what played out at this Code of CCT is that the prosecution had based its case practically on hearsay. And that is what the Supreme Court has observed. In fact, the Supreme Court went in again to evaluate the judgment of the Court of Appeal and discovered that while Court of Appeal agreed with the Justice Omar Danladi's late tribunal that the evidence that was tendered had no link or direct link with the witnesses, but went as far as to also upheld that there is a meritorious charge of charge 4, 5, and 6.
Let's rest on the demerits of the prosecution's case for now, but let's look at the concern that expressed by even public office holders and political watchers that this trial may have been traded for political exigencies. If you look at the political undertones that, transpired between the legislature and the executive ahead of this Supreme Court's verdict. So how true or how weighty is that concern?
You see, in some quarters, it has been said that the Saraki's prosecution in CCT was politically motivated. And you see that what played out, that Saraki's problem started from the day that he was, he came up as the Senate president. That decision, or the way and manner he came up, did not go down well with the powers that must be in the ruling party. And from that day, Saraki had problems.
So in the last 3 years.
In the last 3 years.
In the last 3 years.
In fact, if you
have those political undertones distracted the prosecution from its case?
What is there is that the case itself is allegedly to be a politically motivated case. And because it's politically motivated, it took a lot of the parliamentarians' time and the time of the country, of Nigerians. And who suffers it the most is the common man. Time has come, and it is now ripe for politicians to know that they can no longer, put their own interests above the interests of Nigerians that elected them.
Kennedy Osunwa, many thanks for your time.
Thank you.